The role of Hadith in Ikhtilāf among Muslim jurists. Conclusion. Epilogue. At the end of my study, I may draw some conclusions and underline some of the points which I have discussed in this thesis. It has been my endeavour throughout to throw more light on Hadith, Ahad, Da'if and Mursal, because these are a vital factor in juristic disagreements. On the other hand, I dealt very briefly with Hadith Mutawatir, Sahih and Hasan. They are more or less unanimously accepted by jurists and therefore have played no significant role in juristic disagreements. I have also discussed the concept of Nasakh concerning Hadith, contradiction, and the juristic principles of preference. I would summarize the main conclusions as follows. Firstly, the conflict among scholars caused by the disagreements of a Hadith is furu'i, subsidiary in nature, which relates to their accepting or rejecting some of the Hadith. It is not a conflict in usul that would challenge the authority of the Sunnah as a source of law. Thus, it has been confined to secondary details of jurisprudence and thus does not extend beyond the basic usul of the faith. Second, the disagreement with regard to Hadith that has taken place amongst jurists can somewhat be narrowed down, but cannot be done away with totally. The basis of this disagreement is that some of the jurists have acted upon a certain Hadith and others have not. As for the causes that led to this variance in practice, they are manifold. A particular Hadith may be authentic according to one jurist and inauthentic according to another, for a jurist may lay down certain conditions for its acceptance. Similarly, the meanings of Hadith may remain obscure to a jurist who, therefore, refuse to act upon it, or a Hadith may be accepted by a jurist, but he may prefer another Hadith that contradicts the former and is more authentic. Here are some of the causes that lead to the juristic controversy concerning Hadith. Most of the above causes are repetitive and continuous in nature. They are related to the understanding of an individual jurist and his method of deduction. This disagreement is bound to occur in all places and times. It is impossible, therefore, to unite all the Muslims under one school of law. Third, my emphasis throughout has been to show that Hadith, as one factor of juristic disagreements, has played the most extensive and important role. The conflict over the Quranic authority is limited to the implications of some of its expressions, and the fact that some of the verses have been abrogated or not. It is not actually more than is the case of the Sunnah. It includes, as I have mentioned, the disagreement of the authority of some kinds of Hadith, like the Mursal, Ahad and Da'if, in reconciling conflicting Hadith, and the disagreements originating in the extent of the scholar's knowledge of Hadith. Thus we realize that the disagreement caused by the differences in attitudes concerning Hadith is deeper than that which concerns the Quran. Moreover, the numerical quantity of the Hadith exceeds far beyond that of the Quranic legal text. This becomes very clear when we look into the books of Ahkam and see how much it relied upon the Hadith. The disagreements look so wide and covers all aspects of jurisprudence. I may summarize the role played by the controversy over Hadith in jurist disagreements in their legal works as follows. Number 1. The disagreements on the authority of some kinds of Hadith, for example Ahad, Mursal, Da'if. We find jurists like Shafi'i, Hanbal, who did not stipulate any condition to consider the Hadith's authority, except its authenticity. And when others like Malik and Abu Hanifa accepted it with conditions, in the case of the Mursal and Da'if, some scholars considered it as an authority without question. Others absolutely denied their authority, while another group stipulated some conditions for their acceptance. 2. The disagreements regarding the abrogation of Hadith. The conflict arises here over the possibility of the Ahad abrogating the Mutawatir. I have mentioned that the majority of the scholars do not see that, while others accepted it. I have also mentioned that this disagreement existed only in theory and did not have any effect on the practical rules, because we cannot find a single example for that. However, the dispute over the historical facts concerning the Nasakh did have its impact on the jurists' works on practical issues. Here we find that some jurists accepted the abrogation of certain ahadith, which follows that they do not consider its authority, while others hold it as valid and accept its authority. 3. The disagreement regarding the conflict of hadith and the methods for reconciling it. It has been shown by now that the majority of the scholars adopt the view that the conflict in hadith is cosmetic and not substantive, while other scholars maintain the opposite view. The fuqaha also differed in the methodology of reconciling the conflicting hadith. Some preferred reconciliation over preponderance over one hadith over another. Some choose the opposite. The fuqaha also differed on the factors that make one hadith preferable, and that is because of the multiplicity of those factors. Some of them concern the text of the hadith, while others concern the sanad, and yet others concerned external factors. There is another role which I have not yet mentioned in the text of this thesis, though it played a very important part in the jurist disagreements. It is my conviction that this role is only historic and should not exist anymore. This concerns the great variation of the scholars' knowledge of hadith. Ibn Taymiyyah opined that the only reason why some scholars did not employ certain hadith was because these hadiths never reached them. This was the basic reason for the conflict between some of their opinions and the hadith. It is a well-known fact that hadith circulated in different regions with the migration of the companions to various parts of the Muslim world. It was impossible, therefore, that one individual have the knowledge of all hadith. We have seen that even Abu Bakr and Umar were not aware of the existence of certain hadith, although they were the closest of the companions to the Prophet. Then came the followers of the companions, and each of them learned from the companions whom they met. So whoever learned from a hadith acted according to it, and whoever did not exercised his own ijtihad, which might have conflicted with the hadith. The same ijtihad became the opinion of his students who adopted his school of law, and thus spreading some opinions that disagreed with the Sunnah. This applies also to the leading imams like the four imams. Later, some scholars undertook the task of collecting the hadith and did some extensive travelling in other countries in what came to be known as the hadith-seeking journey. The outcome of this campaign was the documentation of the hadith in the books of compilations like the Masanid and the Sunan and the Sahihain. As a result of this development, they came to know new hadith, and they reached some conclusions on their basis. Their views sometimes contradicted the views professed by their imams. Other scholars continued to follow the opinions of their imams and did not accept the hadith that came to their knowledge at a later stage, arguing that it might have been either abrogated earlier or was a da'if hadith, therefore of weak authority, thus avoiding to admit their imam's ignorance of the said hadith or his departure from it. In this way, the conflict that struck between those that stuck to the Sunnah and those who adhered to his imam's opinion was widened. The compilation and documentation of the Sunnah left two important marks on jurisprudence. First, change in many views and feelings because of exposure to hadith after the collection, compilation and publication of the hadith books. Second, disagreement amongst scholars due to the fact that some continued to hold their opinions while others had changed their views to conform with the newly exposed hadith, which had contradicted their earlier position. Dr. Nabahan says that the belated writing of the Sunnah is the most important factor among the many reasons for the scholars' disagreement. More than one of the scholars who were concerned with the study of the history of Islamic jurisprudence underlined this fact. Had the followers of the early imams shifted from the views of their imams to the rules of the hadith, much of the disagreements could have been avoided. But the stagnation that caught the jurists and their works on the one hand and the fanatical adherence to the madhabs on the other prevented that. We find some scholars went to extremes in exhausting the opinions of their imams and made them the final authority in light of the Holy Scripture. Al-Karhi, one of the Hanafi scholars, gave a good example by saying that every Quranic verse or hadith that contradicts that was reported on the authority of Abu Hanifa and his disciples is either mansukh or reinterpreted. Note how he favoured the opinion of Abu Hanifa and his disciples to the Quran and the hadith just because of his deep trust in them, which led him to wrong conclusions. Yet the history of Islamic jurisprudence is not void of incidences where scholars and their students changed their positions whenever the conflict with the Sunnah became clear. We have already mentioned examples of the practice of the companions. We find the same attitude in the works of the Imams of the four schools, where Shafi'i's complete departure from his old madhab to his new madhab after his trip to Egypt presents a good example. The Hanafi school also provided a good example in this regard. The fact that Shaybani and Abu Yusuf disagreed with Abu Hanifa on various legal questions whenever they found an authentic hadith that contradicted his opinion indicates this liberal attitude. The case of Shaybani when he changed his writings on whether vegetables are liable to zakah is well known. He met with Malik and discussed it with him, and when he found that Malik's opinion was based on stronger evidence, he shifted from Abu Hanifa's position on the matter to that of Malik and says, if Abu Hanifa himself came to know about this evidence, he would have changed his opinion. I do not intend to proceed here in proving the fact that many researchers have disputed. It suffices to mention some legal works which support my argument, together with some comments made by distinguished scholars. 1. The hadith which Abu Dawud and Tirmidhi have transmitted that states that the quantity of water, if it is enough to fill 2 jars, then it never becomes unclean if contaminated by an unclean substance. Ad-Dihlawi comments saying that this hadith was not well known in the time of Sa'id ibn Musayyib or Zuhri, and that is why neither the Malikis nor the Hanafis considered it, while you find that Shafi'i uses it in his legal judgment as soon as he finds it to be authentic. But the others continue to maintain their previous position, regardless of the position of the hadith. 2. The hadith of the session choice means that 2 parties of a contract have the choice of breaking the deal until they disperse. The contract is then concluded and the right to withdraw is no longer available, unless they both agree to terminate it. Malik ignores this hadith because the people of Medina do not follow it. The Hanafis too do not accept this hadith because it is not confirmed by the practice of the people of Medina, but because they interpret the word to disperse in the hadith, yatafarraqa, as meaning to depart in opinion and not physically. Al-Khafif comments that it seems that the cause of this disagreement is the scant knowledge of the texts that indicate the existence of the session choice, and the Medinan practice of disregarding it is based on ignorance of its existence. 3. The hadith reported by Sa'id ibn Abu Sa'id al-Khudri that a man entered the mosque while the Prophet was giving a talk, and the Prophet ordered him to offer 2 light rak'ahs of prayer. The hadith has been transmitted by Muslim and others. We notice that while both Ahmad ibn Hanbal and Shafi follow the rules of the hadith, Abu Hanifa, Malik and Thawri do not. Khafif says that the only possible explanation why these scholars contradict the hadith is because they either never knew of it or they are not sure of its authenticity. There is a hadith that says no marriage contract could be performed without having a guardian to attend on behalf of the bride. Different narrations of this hadith are transmitted by Abu Dawood and Tirmidhi and are followed by Shafi'i and Ahmad ibn Hanbal, while Abu Hanifa and his disciples ignore it. Later on they try to justify that by criticizing its chain of transmission or reinterpreting the text, but they failed. We cannot explain the attitude except by saying that these hadith were not known at the time by Abu Hanifa, or at least they were not confirmed authentic, and that made him to rule contrary to its content. These examples show clearly the effect of the varied knowledge of hadith among the scholars and their agreement and disagreements. Their disagreements are understandable in times of the early Imams, before the compilation of the hadith, but it's certainly not acceptable in latter times when the latter scholars contradict the hadith to adhere to the opinion of their Imams. This brings us to the conclusion that the disagreement which was caused by the unawareness of the scholars of the existence of certain hadith is not relevant today and should cease to exist. There is no need either to justify the position of the scholars at the expense of the hadith, for the Imams themselves will not accept it. This is clear from the explicit statements which encourage adherence to the hadith in practice and ignore their own opinions when they come into conflict with the hadith.